Well, so I didn't mean to interrupt you if I did,
Oh, that's all right.
but you're aware that Susan Margulies is one of the authors of what we all call the praying study, right?
Right.
And the praying study is the leading study that raises the questions about whether or not a person can shake a baby with sufficient force to cause the injuries we talk about in these cases. That Susan Margulies is one of the authors with Michael Prang on that study.
I'm aware of that.
And their study has been used for that purpose because that is precisely what their study says. Nobody is making up words. They said that. Are you aware of that?
I'm not sure what words you are referring to that I'm supposed to understand, with all due respect. But may I quote from Prang et al., including Dr. Margulies, from their 2003 study?
If you, yeah, that's fine.
And I quote here, although the anthropomorphic test dummy data are useful regarding falls and inflicted injury events, the results cannot be used to predict injury. Regional tissue thresholds are required to predict injury, and they are unavailable for the pediatric population. That is from Prang et al. 2003.
And you know that the research in the biomechanical engineering world has continued. That was 13 years ago. You know they have continued to study and issue more reports in this area.
That's true pretty much across the board, isn't it?
And I mean, it's true in every
Yeah,
area.
sure. Yeah, you're right.
And you're aware that the very issue that you are raising and that the other states experts have raised, the very issue about whether or not this is legitimately applied to the situation of child head injuries, whether the biomechanical engineering studies are legitimately applied to the issue of childhood head injuries. You are aware that these very same arguments that y'all have been making here were specifically rejected by both the New Jersey and the Michigan Supreme Courts.
I can't comment on that.
Okay, but you know this. I mean, I know you're not saying you came up with these arguments. I mean, these arguments are out in the field, and people have been making these arguments for a while.
You know, I don't know what other people have been doing. I know what the courts that you're referring to. I know a little something about what they've decided. Um, you know, I think you questioned whether, you know, doctors should critique the work of biomechanical engineers. And I'm not really critiquing their work, at least not most of it. I wonder if it's analogous, whether lawyers, like say Dr. Finley, should be critiquing the work of physicians.
Well, and did you read Professor Finley's reports in this case?
I have seen Dr. Finley's report. It came in late, and you know, but yes, I have seen it, and I've read some of the work that he's written in the past.
And he's not, and I mean, tell me if you disagree with this.
Sure.
What Professor Finley is doing is summarizing the studies and the effect they have in the legal arena.
You asked me if I understood that that's what he was doing.
That is what I'm asking.
May I share then in response what I think he is doing?
Okay, sure. Go ahead and tell us.
I think he is appropriately concerned about overdiagnosis of abuse and is making probably very good faith efforts to remedy that. In so doing, this is a high stakes area, child abuse. And if you get it wrong, either way, overdiagnosis, underdiagnosis, you've got adverse effects that you want to avoid. And they're major adverse effects. If you overdiagnose it, you are disrupting families. It can lead to, in certain circumstances, to incarceration. Um, if if you don't get it right and you call it when it isn't really there, you're creating all kinds of problems. But if you underdiagnose it, you have a different set of problems. And you're putting children at risk for subsequent injury or even death. Now, I think what we need to do is get it right, not underdiagnose, not overdiagnose. Now, my opinion of what Dr. Finley is trying to do is he's trying to lower it so that we miss, uh, so that we have less overdiagnosis. But in so doing, I think what he is doing is putting us at risk for missing cases or having the folks that are by law charged with protecting children less aggressive. I think he may not realize, but in my opinion, he's causing some unintended consequences or and potential unintended consequences that are unfortunate.
Am I causing some unintended consequences that
You're
are
doing your
unfortunate?
job.
Okay, so I mean,
You're doing your job and you're doing it well to advocate for your client, and I totally respect that. Dr. Finley is doing something else.
All right, we're back on the record. State's attorneys are here, applicant's attorneys. Mr. Garner's here. Mr. Udishin, you may proceed.
thank you, Your Honor. Dr. Edwards, let me start with what I think is an easy concept, is that if you accept the biomechanical engineering studies concerning shaking alone, if you accept those, then there is just simply no question that there's new science on the shaking theory. Would you agree with that?
I think so. What do you mean? What do you mean by accept? Accept that they are.
Well, that's good. That was too vague. Let me tell you what I mean. Let me rephrase it.
Okay.
What I mean by accept is that you accept that they are engaging in a legitimate scientific process in performing those studies and issuing those reports.
When they're done in good faith, and I think most of them are. I agree.
So the issue about biomechanical engineering in your view is not whether it's a legitimate area of science. I mean, you agree that it is, right?
I've done that, yes. I've already done that.
And they do a lot of work in a lot of different areas that you certainly have no qualms about following their recommendations.
Yeah.
Okay, so is the only area that you're aware of where biomechanical engineers have done research and issued reports that you have any question about is in this area of shaking?
That's an interesting question. You know, I don't have a problem with the work of Oates or Margulies or Prang or Corey and Jones, etc. I don't have a problem with their work. The problem I have is with the extrapolation, what I consider to be the inappropriate extrapolation of their work to human infants and children. And I think most of them would agree with me, because you will find, if you look, you don't even have to look carefully, you will find in most, maybe not all, but just like we found in Coates, statements recognizing the limitations of their work and warning, but they don't use the word warning, but let me use it, essentially warning us as the reader to be careful about using their work to predict injuries in human infants. So I don't have a problem with their work. I have a problem with the way some people extrapolate their work that I think they would agree with me. I shouldn't try to speak for them, but I do think at least most of them would agree with me it's inappropriate.
Okay, well, you are aware that at least two Supreme Courts in other states, New Jersey and Michigan, have said something to the effect of biomechanical engineers are really not qualified to critique the work of physicians, just like physicians are not qualified to critique the work of biomechanical engineers. Were you aware that those two Supreme Courts from those states have said that?
At least in a macro. I mean, I'm not familiar with the details of the cases, but yes, I've heard that. Yeah.
But isn't that, I mean, isn't that really what you're doing is you are a physician and you are critiquing the work of a whole different scientific field?
No, no, I am not critiquing their work. I am critiquing the extrapolation of their work. And I think that I'm in agreement with them. They don't want their, the ones I've read, I think Susan Margulies would not appreciate her work being extrapolated inappropriately, and likewise Brittany Coates.
What you just watched was not simply a battle between a prosecution expert and a defense attorney. It was something rarer and more uncomfortable, a genuine philosophical argument about the price of getting it wrong. Dr. George Edwards did not come into that courtroom as an ideologue. He came in as a pediatrician who had spent nearly 5 decades watching what happens when children are hurt by the people who are supposed to love them. His research on confessions in abusive head trauma cases spans 434 cases, 55 studies, 15 countries, and 4 continents. And when the defense attorney pressed him on whether any of it could be trusted, whether the confessions were coerced, whether the science was misapplied, whether the father's admission even counted, he answered every single question without retreating a single step. But the moment that may have mattered most was quieter than the confrontations. When he was asked whether people convicted of child abuse are bad people, he paused. And then he said that child abusers are not monsters. They are people who have had a monstrous moment. That is a compassionate view. And it coexists in Dr. Edwards' mind with the belief that lowering the diagnostic standard, even in the name of protecting the innocent, is a policy that will cost children their lives through missed cases and under aggressive intervention. The defense worked to undermine the confession research, challenged the biomechanical science, and raised every legitimate critique available. The doctor acknowledged what was fair to acknowledge. He did not acknowledge what was not supported by the data. At the end of the day, whether or not you agree with the diagnosis, one fact stayed constant throughout this entire hearing. Callan Garner was 2 months old. He was alive and normal in the morning, and he was dying by the afternoon. Someone has to answer for that. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.